All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in three cases this morning. First one is 22-166, Fleming against Wilson from Harris County and the 14th Court of Appeals District. Justice Devine and Justice Busby are not participating. Then second, 22-459, Seeley Emergency Room versus the freestanding emergency room managers from Harris County and the First Court of Appeals District. And then finally, 22-872, In re Illinois National Insurance, petition for writ of mandamus from Harris County and the 14th Court of Appeals District. Justice Lerman, Justice Huddle, and Justice Young are not participating in that case. The court has allotted 20 minutes for each side in each of the cases. We'll take a brief recess between them, conclude the arguments before the lunch break. The arguments are being webcast live this morning and will be in the court's archives later on. We're ready for argument in 22-166.
May it please the court, Mr. Gunn and Mr. Fogler will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal. Mr. Gunn will open with the first 10 minutes and present the rebuttal.
Good morning, Your Honors. May it please the court. This lawsuit by 4,000 plaintiffs has been on file since 2010, and in those 13 years we've had one trial by 6 plaintiffs who went to trial, had a 9-day trial, lost, and that was affirmed.
It would have ended a lot sooner if you had not successfully opposed class certification.
Your Honor, that was a separate case where the federal judge said plaintiff didn't carry their burden to justify it. We were looking at what we thought was the law of 50 states, different rules. By the time we got to here, we are looking at what you see here, a fight over $32,000 under Texas law, under the highest hurdle that we have to get.
Why is it all still under Texas law? You were wrong to think that other states' laws might govern it before, but now it's just Texas.
That's the case the plaintiff tried. That's what they put on. That's what they went. They didn't.
But it was a 6-person trial.
Correct.
Not a 4,000-person trial.
It was 6-person trial, and if I understand their position, it is they can keep doing this for as many decades as it takes, maybe until they come up with the lucky 7 and say, aha, now we're done, we've won one. We're asking you to reject that world and to reinstate our summary judgment based on collateral.
If they were to say today to us, you know what, that one, of course, we can't go with. We didn't expect the use of defensive collateral estoppel, but we're still good with a single trial. The next one, as long as both sides agree to it, we're all in. As long as both sides agree that this will bind the other. Would you accept that deal?
Well, it's baseball season. We might go for 4 out of 7, I think, Your Honor. I mean, we would discuss it, but there are undecided questions about offensive collateral estoppel under the state constitution, which you've reserved and which we feel like have some value. With offensive and defensive are fundamentally different. And by the time we got to here, look at what we had to get through. The burden was shifted to us as the defendant in trial. The hurdle was raised. We thought this was just a contract case. They said, no, it's fiduciary duty under pattern jury charge 104.2. And you've got a very high burden as the defendant with the burden shifted. And we won that anyway. So my question, which maybe they'll tell us when they get up here, is what's going to be different the next time? Well, this is not mass tort. This is mass contract. And we're here under Section 40 of the Restatement of Judgments. That's the rule we're asking you to adopt. I know it won't dispose of every case that has a lot of claimants, but it never was intended to. it will dispose of some cases on the common sense notion that parties can agree, they can consent. I don't mean agree in a contract sense. They can acquiesce or consent and tell the judge, this is it. And
Even if we rule for you generally on that idea of an implied agreement, do you lose on this record?
that's the right question, Your Honor. Let me tell you why we don't. The answer is going to be the Caulfield case from the Fifth Circuit, which is in the reporter's notes in the restatement. That's where we are. The other side has argued Benson, and they say, well, look, car wreck, 2 families, everybody gets a day in court. I'm not asking, Justice Lerman, for a rule that would take care of mass torts. It's very rare where you're going to see mass tort claimants, like a refinery explosion, a plane crash, a bus wreck, where they all say, this is how we're doing it. That is night and day different. On our record, we have several crucial circumstances that set us apart, and I'll just walk through them. Number one, you have the same counsel. That's one of the factors in the restatement. That's not per se enough, and we don't claim that it is. But you do have the same counsel. You have them on the same pleading all the way through right before trial.
How is that different than an MDL case, though, where lead counsel represents any number of individual actions in connection with pretrial rulings, but the anticipation is that each individual case will be remanded for trial? And it seems like you're advocating something that's very close to virtual representation.
And I don't want to go that far, Justice Bland. You're right. I don't want to go that far. I don't think that the typical mass tort, which is what most MDLs are, that the typical mass tort would be covered. It's got to be more than that.
What about a consumer contract? You've
Well-
got 10,000 consumers all had the same purchase agreement. If there was something about the agreement that was deceptive or misleading,
I would
why would that
Right.
not fall under your rule?
Well, it would fall under my rule if we've got the triggers that came from my friends on the other side. Not just same counsel, but same pleading all the way to the 5-yard line, and then they hand the ball off to 6 plaintiffs to say, get it over the goal line, and we're all going. And they said, this was our plan.
What if the verdict had been mixed? What if the jury had awarded damages to some of the 6 and not others? What would we glean from that under your rule?
I guess I'd have to look at it. That's one of the points I think Caulfield made was, look how easy the burden was on the plaintiffs, and they still couldn't get there. That's Judge Hutchison's statement for the Fifth Circuit. And we're claiming that. This is the hardest burden there is on a civil defendant when you've got the burden shifted to you and you've got to prove those 5 things in 104.2. And remember, Your Honor, they said it's uniform and it was always their plan. So that makes sense when you look at the damage. $32,000, why would you have a week-and-a-half trial over $32,000 unless you're planning just to replicate it and to be done? I don't know how they get out now. It's either, it seems to me for the court, it's either we do this 1,000 times or we say, we're done, just like the Fifth Circuit said in Caulfield. That's our rule. We're not asking for something that would say your classic bellwether case would bind everybody else. No, it was from what they said to the trial courts. Uniform, same, it's identical, we've always planned collateral estoppel. The court can take them at their word.
So they always said that.
They did.
But you said the opposite, and you prevailed. You got class certification, rejected. I get it in the other case, but they would have been part of the class.
Right.
And you made the representations to that court about them not being uniform. They're nowhere near identical. There are all these differences, not just of state law, but of other things as well. And then you stopped them from having a single trial in state court, fought very hard and prevailed in that. So my question is, why is that not something that judicially stops you from contending that they are uniform and the same? They lost that point. Yeah, they said it, but they lost. You won.
Well, I'm saying this is between them and the judge. It's between the plaintiffs and the court. And the plaintiffs told the court, uniform, and that's their plan, and the court took them at their word.
But the court did not allow them the payoff for the representation that they made. That's the point I'm trying to get you to help me with is,
Right.
if the point of them saying all that was, Judge, it's uniform, it's all the same, you should let us have a single trial, one big thing. There's no point in this. Judge, you should let us certify this class, and the judges won't do that. Why is it that we're going to hold them to that representation when they didn't get the thing that the representation was made for?
I'd just say that's Caulfield, and that's.
Doesn't the reporter's notes sort of speak of Caulfield without complete approbation?
I think that's, it's fair. It says it's somewhat ambiguous on the facts. I didn't find it ambiguous. I found it congruent with our facts. And you can say, we don't agree with Caulfield, but that's our case. Our case is not Benson, the car wreck case, the refinery explosion, anything like that. So as Justice Lehrman was getting at, I think the rule is pretty sound. I don't think you're going to hear much of an argument against the legal rule. The question is, how do we apply it here?
So illustration 3 is,
Yes.
is perhaps helpful, but there it says C requests deferral of his suit until the trial of A against B.
Right.
And that seems the opposite of this case, in which they wanted to do a class action. They wanted to do a single case for everybody. They didn't request to hold back. They said, okay, fine, if we can't do a class action, if we can't do the full thing, we'll do the mini trial, we'll do the representative trial.
They have a burden under Federal Rule 23 if they want a class action, and if they can't meet it, it's not my fault.
I'm not talking about that. I'm talking about whether or not illustration 3 applies, because if they did not request to defer their suit, the remaining members of the Wilson group.
Well, I don't see how that's different from what happened. We've got 4,000 plaintiffs, and they say, let's sever out 6 and put them to trial. One's going to trial and one's not. That looks to me
I
like
thought they
they're
wanted to do everything all at once, and that you successfully stopped that from happening. Am I mistaken?
I don't think they wanted to try 4,000 people at once or
Okay,
anything.
I'll ask them about that.
And I don't think it's possible. The upper limit, practically, I'll yield in a moment to my trial colleague who can talk about the practicalities, but the upper limit for the number of plaintiffs in a single case is what? A dozen, 15, 20, or else you can't keep track of them. The plaintiffs testified here. It's either Groundhog Day for the next 50 years or one.
Traditionally, collateral estoppel applies when certain elements are met without regard to whether the estopped party consents or agrees. It's just,
Right.
you're collaterally estopped if these things are true. Implied collateral estoppel, does it necessarily rely on some implied consent or agreement? Or is it implied elements are met?
I think it's an implied agreement. I would
And
say.
if that's the case, then why doesn't Rule 11 prevent it from applying in Texas?
Oh, because
Because you gotta have an agreement.
No,
You
not
just
between the
said-
parties. I'm talking about an agreement with the court, consent or acquiescence between the litigant and the judge, not between the two sides. If it's between the two sides, Rule 11 would cover it. Thank you, Your Honor. Mr. Fogler.
We'll hear from you.
May it please the court, I want to respond directly to the comments about, well, didn't you oppose the class? And it's true that we did, but the problem that the plaintiffs had here and the reason why they wanted collateral estoppel is because of the practicalities of this case with 4,000 plaintiffs and trying to put on a cookie cutter case. So the plaintiffs are the ones who, after the class was denied, they then put in their pleadings, this is our alternative to class. We want collateral estoppel to apply here because otherwise it's uneconomic for them, for all of us, for the courts and for everybody to try this case over and over again. Because we have one document, a settlement package that was mailed to all 4,000 of these, actually 8,000 of the settling plaintiffs, identical in every respect except for the proportionate numbers to each of the individual plaintiffs. And so the issues that are going to be tried, as the plaintiffs themselves have repeatedly stated, are the same breach of fiduciary duty, the same did you comply with your agreement. Those were the issues that were presented in a long trial in this case and decided against them. And the reason why they wanted the collateral estoppel is the reason why the rule that we're advocating needs to apply. And if the court has no further questions, I'll cede the rest of my time.
Any further questions? Thank you, Mr. Fogler. We'll hear from the respondents.
May it please the court, counsel. In answer to your question, Your Honor, if going forward, if we could try one for all the marbles, yes, we would do that. Also, in answer to your question, did the plaintiff seek to try all the cases? Yes, we did. You can see in Exhibit 8 on page 2, it was the Fleming defendants. They state right there, they were opposing that. They said it is impossible to try all the plaintiffs in one trial. They were the ones that were against that.
Well, there's some practical realities with that number of plaintiffs. I mean, 4,000 plaintiffs to come in and testify about their case?
Yes, Your Honor. My point is just that we were not seeking deferral. They were just taking the position there's practical realities, as you say. So that was the reason for trying a group of them, not that we were seeking deferral as in relation to illustration 3. I'd like to direct does that answer your question?
Yes, if you had won, would you be seeking preclusive effect in connection with the remaining plaintiffs?
If we had won, we had in our pleadings offensive collateral estoppel. They had defensive collateral estoppel, but they would never agree to be bound. So we never agreed in advance that both sides would be bound. They had already opposed collateral estoppel successfully. So it was obvious that they were going to do the same thing. If we won, they were going to oppose it again. They'd already won once, and they probably would have won again, especially, with that court.
But I guess the question was, what would you have done? Would you have argued it? And was your theory of why we should be going about this sixth plaintiff trial that it was going to dictate the outcome of the whole thing?
We would have argued in favor of the elements of collateral estoppel, and we would have argued that we met those elements. And
so your theory of the case at that point was, let's have this 6-person trial, and we're gonna win that, and then that's gonna dictate the rest of the case.
Yeah, but offensive and defensive was different in this case because the defendant that litigated and lost would have been the same. So you didn't have that problem. So you weren't missing that element for seeking offensive collateral estoppel. For them seeking defensive collateral estoppel, they have a problem because they're seeking it not against the litigant that already litigated and lost. They're seeking it against different people. So that's the hurdle for them. And that's why if they wanted it to apply to everyone, then they have to agree in advance, okay, for all the marbles. But they would never do that. So they had that problem with proving their elements.
So your position is not that the 6-person trial can only serve as the foundation for the ruling as to everyone. You're not saying that can't happen. You're saying that can only happen if the plaintiffs win the 6-person trial.
Can only according to the elements of collateral estoppel, it can only happen offensively. That's true, unless they would be willing to agree in advance. This is a case for all the marbles, but they would never do that. We would have been willing to consider that. They would never agree to. Like I said to him, going forward, we would agree to a case for all the marbles.
Well,
so
is that not? I don't think that's all quite right, is it? If it's defensive, it would still apply without them agreeing to anything. If you all were, the word privity is maybe not the best word. It's a word with too many meanings. But if you all have those as non-parties, are sufficiently linked under Section 40, under Taylor versus Sturgill, and that's really the question, right? Were the remaining members, even though they were not the 6 parties in the trial, in privity with those 6?
You're correct. The question then, if you go to restatement, is did we have an agreement to be bound by that? And to that, I would like to turn to Exhibit 3. So what is an agreement? They talk about the factors of an agreement. Restatement has some factors for how you can find an implied agreement. But what it doesn't talk about, what's required in every agreement, is mutual assent. If you don't have mutual assent, you don't have an
Do you
agreement.
think there's a contract between the two parties, like some commercial agreement, as opposed to
Well,
something you represent to the court?
Well, agreement is not exactly the same as a contract. It's broader than a contract, but an agreement requires mutual assent at the very least, even if you don't want to say it's a contract. But if you look at the restatement, I'll quote to you, the third page of the restatement says, "A stipulation or other agreement to be bound by another's action can be viewed as essentially a matter of contract law."
So I think the argument on the other side is that the nature of the agreement is not an agreement between the plaintiff and the defendant, but an agreement between the parties who are there to represent the interests of the remaining individual action plaintiffs. And so the agreement is really not an agreement between opposing sides, but really an agreement, sort of an agency type of agreement, that I will adequately protect your interests, or the trial court will adequately protect your interests. So do we have enough here to conclude that agreement exists?
No, the restatement says this type of agreement they're talking about, you can either make it with the opposing party or with the court. They have claimed, their position is, that we made this alleged agreement with the trial court. That's their position. So you have to ask, do we have mutual assent with the trial court on this agreement? And to that question, we can go to Exhibit 6, please. They talk about the statements that we made back in 2011 when the Kinney plaintiffs won and we were seeking offensive collateral estoppel at that time. And they've got the statements that we were making in favor of collateral estoppel, and this also includes the statements that they were making against collateral estoppel. So the question is, who achieved mutual assent at that time? Because we were pro and they were anti-collateral estoppel. So you got to go to the court. Who did the court side with? Because whoever the court sided with, that's who obtained mutual assent, and the court sided with them. And so this is what they said. They said, "This is not a de facto class of 4,000 plus individuals as the Wilson plaintiffs would have themselves treated. Defendants handled each Kinney plaintiff's case individually and will do the same for each of the Wilson plaintiffs' cases. Both the court and defendants dealt with the Kinney plaintiffs individually throughout the litigation and at trial as well. For example, individual discovery was taken of every plaintiff, and each Kinney plaintiff put on her own testimony at trial. Additionally, the jury made findings as to every plaintiff because each one of the 10 was named separately in the charge. The same must occur with every one of the Wilson plaintiffs." So they're saying you have to try to the jury every single one of the Wilson plaintiffs. That's an absolute anti-collateral estoppel position that precludes offensive collateral estoppel, that precludes defensive collateral estoppel, and the court agreed with them, ruled for them. So they have mutual assent with the court. So according to their analysis, they have an agreement to not have collateral estoppel that they should be bound by because they have mutual assent with the court. But we do not have mutual assent. All their statements that they quote from us, as the justice pointed out, were rejected. The court did not mutually assent with us. It ruled for them.
So do you agree that if we identify the issue as whether there was either express or implied mutual assent between the plaintiffs and the trial court, and that's how Mr. Gunn has characterized the issue, and you've agreed with that characterization of the issue, that under that approach to the issue, Rule 11 doesn't apply at all?
Yeah, if you're talking about the trial court, it doesn't apply. I mean, there were times when they were implying that it was an agreement with the parties, and they were saying, "Oh, we have a rule." They've backed off of that.
So
now,
basically, the whole Rule 11 issue is no longer relevant in this case before this court?
because they're conceding that there's no agreement
Okay.
between the parties, but they're saying that there's mutual assent with the trial court, but they don't have it. So that's their big smoking gun. They have that quote when we were seeking it at that time. They're like, "We got you. You were in favor of collateral estoppel back in 2011. We got you. You have an agreement with the court." Well, we don't have an agreement with the court. Look at how the court ruled. The court ruled for them.
You agree that Section 40 is a correct exposition of Texas law?
I I wouldn't say that. I mean, the court could adopt that. I don't think that is the current state that an
Is there
agreement.
anything in it that is inconsistent with Texas law?
Well, I would say, I would like to, sort of on that point, let me go to Exhibit 4, Illustration 3. Okay, and the analysis that the Fleming puts forward all throughout their briefing is heavily reliant on Illustration 3. Okay, Illustration 3, and I guess you're familiar with it, you guys were quoting it. The relevant part, I'll just read the middle line, the bold. It says, C requests deferral of his suit until the trial of A against B, stating that the two actions involve identical issues and that the deferral will prevent duplication of trial proceedings. Okay, that is a purely unilateral act. That does not involve two people. Okay, all it's saying is C is making a request.
So I think you're telling me that if Section 40 applies, that you can still prevail. But my question is Section 40, does it have anything that's inconsistent with Texas law? And then we can move on to applying it.
I would say, if you're calling Illustration 3 an agreement, yes, that is inconsistent with Texas law. Illustration 3 does not describe an agreement.
Okay, so you're suggesting then that comment B also? I mean, your brief suggested that comment B was something that you did not think that we should embrace. That's the one with the 5 factors.
Well, okay, not for Rule 11. So, I mean, we already addressed Rule 11.
So set
but
that aside.
if you're just talking about the trial court, I would say it's okay, yeah, for that.
Okay, and so Illustration 3, you think that Illustration 3 misapplies Section 40 and comment B?
It does not purport to describe an agreement. That's what I'm saying. And it's
So that then, I think leads to the very point. When you say that an agreement requires all this mutual assent, and the restatement doesn't quite say that, and in fact it illustrates this idea of what we might call an agreement with something that doesn't describe something with mutual assent, that's kind of the point. Maybe what you're describing as an agreement isn't what the restatement means by agreement.
Well, I mean, if just because a restatement illustration somewhere says an agreement can be something less than mutual assent, I mean, I think Texas law principles of agreement completely predominate over somebody somewhere writing an illustration that says you can have an agreement with purely unilateral conduct. That's crazy.
Does Illustration 3 describe an agreement with the court between Party C and the court, in the sense that Party C is asking the court to postpone or abate Party C's trial and saying, if you'll postpone or abate it, then I'll be bound by what happens with Party A's. And isn't the court having to kind of agree to that by postponing or abating the trial?
That's the issue. What does the court do? Illustration 3 doesn't talk about what the court does. If the court grants it, then there's mutual assent. It doesn't it doesn't say this is an agreement. It says at the end, it may be inferred that C consented to be bound by the determinations made in the action A and B. So that's unilateral consent to be bound, but you have to obtain mutual consent to be bound. You have to, the court has to grant it. Then you have mutual consent to be bound, or you can get the other party to agree. Then you have mutual consent to be bound. This is describing unilateral consent to be bound.
Well, it's describing the Party C's unilateral offer to be bound.
Yes,
But
offer.
There's no collateral estoppel unless the court accepts that offer and postpones Party C's trial.
Yes, that's my point.
And then you do have mutuals. So
That's
even
my
under
point.
Illustration C, in order for there to be collateral estoppel, there must be mutual assent between the court and Party C.
That's right. If the court had rejected this principle, that's analogous to what happened here. We offered collateral estoppel back in 2011 and the court rejected it. That's the issue. See, they're saying if you just offer it, that's an agreement. But I mean, you hit on it. That's it, mutual assent. You have to get the court to approve that, or you have to get the opposing party. It doesn't say this is an agreement. It says this describes consent to be bound. And the case law, if
Well,
you...
why isn't the court granting summary judgment against you? Essentially, the court taking you up on the offer to be bound by the outcome of the first trial?
Because that was back in 2011, and they rejected it at that time, and then that's it. That's an offer and a rejection, and we're dead. And then after that, we never discussed collateral estoppel again for years.
But you said that your intent was to raise it after the trial offensively. The restatement provision that we were just discussing, contemplates that kind of a scenario, and then you're saying, well, the court has to do something to give its assent, and I'm saying, it seems like the court granting summary judgment against you is the court's agreement.
We offered offensive collateral estoppel on the Kinney case in 2011, and the court said no, it rejected it. That was the end of it. If you offer something and then they come back and they reject it, and then that's the end of it.
But I thought you said your plan was to raise it again after the Harps trial if you had won.
The pleadings say offensive collateral estoppel. That's what we were seeking. If you go to Exhibit 7, that has our pleadings. It's very clear. We're talking only about offensive collateral estoppel. The opposition had pled only defensive collateral estoppel. So we were not offering to accept defensive collateral estoppel. We were going to seek to prove the elements of offensive collateral estoppel. If they wanted to get an agreement that this was going to be for all the marbles, then we would have considered that. But they would not do that.
What is a trial with, if you prevail and you go back and the trial court tees up another 6 plaintiffs, what does that trial look like? What is factually different about another trial? Or is this really preclusive effect of some legal determinations?
Well, it's not preclusive effect because there is no collateral estoppel, so those plaintiffs are entitled to a new determination.
But what will you present that's factually different?
Well, there are some issues that, for example, the settlement agreement, the appellate court was making some statements in agreement with us that the settlement agreement imposed additional duties on, ethical duties on the Fleming defendants, and we would be able to present that. That would be one component to it. I mean, there's some, that's one major thing that I can think of. I'm sorry, go ahead.
Well, if you want to finish answering.
That's it.
Should it matter that there are 3,994 plaintiffs whose cases weren't tried as opposed to, 2 or 3 or 6? In terms of just the way we conceptualize this and the way we think about, okay, do these 3,994 people really have individual agency in this situation, or are you acting on behalf of everybody? And ought we to think about that differently from a case where there's just a few people who really can sort of individually dictate the progress of their own litigation?
Well, there is an agreement between the Fleming defendants in Exhibit 6 where they are saying the jury made findings as to every plaintiff, every case must be treated individually, the same must occur with every one of the Wilson plaintiffs. They achieved mutual assent with the court at that time. So, I mean, that's the way they're proposing to do it. They want to do it one at a time. Now, we would be open to a case for all the marbles. So, I mean, I think that's realistic to do. But, I mean, if that's not going to happen, we will try them group by group, I suppose. But, I mean, yeah, we are open to a case for all the marbles.
The question about whether or not the non-party, the 3,994, were sufficiently linked to the 6 is really what the case turns on, what this appeal turns on, right? If those 3,994 are sufficiently linked to the 6, the old concept of privity, then you lose, and if not, you win. Is that not essentially the question for us?
Is there privity? Yeah.
So the question then is, if we're going to use the analysis prescribed by the restatement, the illustration that you turned us to in your tab 4 has that one line that seems to help you, that C requests deferral of the suit, and I'm not sure that you really did that. On the other hand, the reason I mention this, I want you to tell me if there's something about this that will make me feel less troubled by it, and that is that you represented all 4,000, and all 4,000, not just the 6, participated in the Harps litigation itself. And so this is not a case in which those non-parties were to sort of off doing their own thing, not a care in the world. They are focused on the Harpst case, the 6. They're fighting off expert reports or trying to get them in. How is that not something that is well nigh dispositive of the privity?
There is extensive briefing on all principles of privity, every nuance of it, everything. That's what we did in the Intermediate Court of Appeals, and we chased that down, every rabbit hole.
I'm not talking about briefing on privity. I'm talking about your defending admissibility of your plaintiff's experts, all 4,000,
Yeah.
not just the 6.
They have to prove the elements of collateral estoppel to achieve collateral estoppel. The thing that they're lacking on is they don't have they are not imposing it against a party that litigated and lost. So the only way they can get there is through
Well, that's the
privity.
question. If you did,
And
if
so-
all 4,000 of them were in fact litigating it in a material
Yeah.
way, I recognize they were not taking the stand,
if there
but they
was-
they were calling shots about strategy for expert admissibility and all this stuff. They are participating in this case.
Only if there's privity. There's a substantial amount of law that says there is not, and the restatement does not apply in this case.
Do people who don't have privity with each other tend to jump in and fight off, challenges to experts and things like that?
There's a substantial case law that says even if you have the same attorney, even if you have the same underlying factual issues, even if there's all kinds of stuff that's.
And I'm saying, all of that aside, I'm talking about actual participation in the 6-person.
Well, they didn't participate in the Harpst trial. They didn't
They
participate.
participated in the litigation. Is that
Well,
wrong?
it was severed.
Yeah, but nonetheless, I'll ask on rebuttal, but I mean, your friend on the other side continues to emphasize, well, I think one of their strongest points is that the plaintiffs, all of them, actively participated in the Harpst litigation.
They did not participate, respectfully, they did not participate in the Harpst trial. They didn't obtain jury findings on all
I
their
get that, not in the
cases.
trial, but in the litigation. But I think we've made the point.
Okay, thank you.
Any other questions? Thank you, counsel. Gunn, you have 8 minutes.
Your Honor, I hope I only need about 2. De facto, as Justice Blacklock was getting at, these plaintiffs are not just joined, but they are litigating agents for each other. There's something of a feud, if you will, between the 2 law firms, and the clients are just along for the ride. They have rights, but they lockstepped to get the rights. Their injuries are the same. It's just proportional. Let me focus on damages for 1 second, because where is the money? It's in the $20 million for the ECHO program of $500 a head. That's where this all goes. And Justice Bland's question, I don't think got a satisfactory answer about how will the next trial look any different. It will not. It will be the same. That they've had their full case. They got to debate, are those charges legitimate or not? Both sides were aired. There were people on one side that they called. There were people that we called. There was a witness who had started on one side, ended up on the other, and said, no, over time I changed my mind. That's fully litigated, and that's where the dollars are. So every trial is going to be the same. I don't think that's a convincing answer that there might be something different, which is why I say it triggers Caulfield. That's the whole point the Fifth Circuit made, was if the burden is that easy, and you've had a 1.5-week trial and you still can't get there, and you can't show us what's going to be different, we're done.
Now, how much money per plaintiff, under their theory of this, are we talking about?
It varies, so that it's not per head, because the way the settlement happened was a grid, and people were in different boxes, because that's the way the drug maker set it up. So it varies. It's down to $50 or $70 for a few, and tens of thousands for others. So it depends on which ones you pull out and say we're going to go to trial with. But the formula is the same. It's proportional. That's the nature. It's the unusual nature of an aggregate settlement. 95% of the clients had to agree before the underlying tort case would settle. They did. The people settled. They got their check. And then they were solicited, hey, let's take another go at it. We think we can get you some more money. And the solicitation campaign paid off, and the number of plaintiffs swelled from 3 at the beginning to a couple of thousand and then to 4,000 by the end. But if those 4,000 have to be flown in from out of state 5, 6, 20 at a time for the next 40 years, it's all going to be the same, and we'll be reading transcripts of the prior trials at some point or playing videos because the witnesses are not going to be here to finish it.
How is that different than any general MDL, though? Where the parties have proceeded with individual actions at their election, or in this case, over your, because of your opposition to a single action. And if we had a rule that you're advocating for, wouldn't this end up requiring any remanded MDL case to be one that would have preclusive effect as to lots of other plaintiffs? And is there any federal court that has done that? And because there's a lot of intersection between federal courts and state courts in these kinds of cases, do we really want to have a different rule for state courts than we do for federal courts?
I want the same rule. I want the restatement rule, and I don't want it for your typical MDL. I don't want it for mass tort. There are so many gradations and nuances in tort litigation over breach, contrib, and third-party fault, and the experts, people have different strategies how they try cases. So it's not just different firms. This is at the other end of the spectrum. Maybe it's a long spectrum, and maybe some cases will be close. We don't think this one's that hard. This is very unusual. You don't see aggregate settlements every day. You don't see what we feel is, at its heart, a contract claim. And then over our objection, we are forced to jump over a much higher hurdle as the defendant. I think that triggers Caulfield.
Suppose that they were to say, you know, it's not that there's anything wrong with the trial, it's just that we didn't really push, you know, this particular theory the way that we could. Or there's some arguments that we could have really emphasized to the jury and we didn't, but, you know, we could. Would that make a difference or not?
I think it would make a difference. And what I'm saying is the money is in the cookie cutter claim. That's where all the money is. Here's the settlement statement you got. Here's the charges that were deducted from your share. Either that's kosher or it's not. So that's where all the money is. I don't see how that ever changes. And, you know, we think it's going to be over and over and over. And I don't think you've really heard much explanation of how there's a meaningful claim to try. It's not a negative value claim. If I'm wrong about that, if they have something else, I don't know why it wouldn't have come out in the trial we have.
Taylor seems to you know, you emphasize Taylor an awful lot, but of
Yes.
course Taylor rejected the idea of there being, you know, Justice Ginsburg works really hard to say, let's not use the word privity, but privity, in that even though the issues are exactly the same, I mean, they're literally the friends of each other seeking the same documents from the government. It's just a matter of law question. Does an American citizen have the right to these records? And the court said, well, no, because an individual has the right to his own day in court unless you can really, in the restatement says, unless it's the plainest circumstance, you should not do this.
And I agree with that. There is a right to a day in court, but not Groundhog Day, not over and over where it is the
That's
same.
Justice Blacklock's question about should we really think of this materially differently if there's 2 or 3 that are out versus 2,000 or 3,000. And I'm not sure the individual rights that are at stake can be discarded just because there are many more individuals whose rights will be lost.
True.
To that right.
True, but it's flip side of the same coin. That's where they got their rights in the first place. That's how they had negotiating power to make a settlement. That's why it is an aggregate. And it's kind of the bitter and the sweet. It goes with the territory. It's no coincidence. They're all in lockstep, and they're in lockstep even today.
So that question, I was hammering pretty hard at your friend about whether or not the remaining 3,994 were actively in lockstep working in the Harpst litigation. Yes. And he said that they weren't, and you haven't really, you know, jumped up to say that I was right in my questions, make me think that maybe I was overstating it.
I think they're in lockstep all the way through. I mean, they're still fighting about experts.
But I'm not talking about in the way through, but in the Harpst litigation itself, the Harpst, the one where the 6 were the named plaintiffs, did the 3,994 actually do the things that I think I was reading from your brief? They collectively defended the admissibility of the experts, the plaintiffs' experts. They moved to exclude experts, all this kind of stuff. In the Harpst, was that in the Harpst?
It was pre-trial. It was pre-trial.
But once Harpst was the 6 named plaintiffs. This is not before that, was it?
Well, I don't recall the precise dates. We went from 2010 until 2016, and then there were motions saying, let's have a severance and pick some trial plaintiffs. And the motion pended for a while. And so the pretrial workup is, people knew, hey, we're going to have a trial, I think it's in November. And so there's this boundary zone in the 2 months from, say, September to November to the trial. I don't see any separation where the papers give any hint, okay, this is just for the Harps 6, and they're gonna do something quirky. This is all the same, and I promise you it will be the same if it goes on, which I will not do. Thank you, Your Honor.
Any other questions? Thank you, Mr. Gunn. Case is submitted, and the court will take a brief recess.
All rise.